mostly because we've been getting calls here and there about, come on in. We've been getting calls asking us that question about charters. It's kind of a topic this fall, and I thought I could probably save myself a lot of time if I just wandered over here and made myself available for a few minutes. However, I do have a couple of things on my mind to talk about. I don't know that either of them are newsworthy, but they might be useful in terms of background for you. The first is, and we passed out our report from early this year on our unannounced attendance audit on community schools that we did last year. We're going to do that again this year. We're not going to announce when, but we're going to follow up and not only do this procedure again, but we're going to add a few components to it based on what we learned. And we're also going to add a traditional public school component so that we have a baseline there. The other thing that I was really interested in, how many of you actually read the White Hat case? Yeah, it's pretty dry reading. Really interesting case. The thing that's different about it to start with is the fact that there's no more than two justices that agree on hardly anything. So the main opinion only has its author. The dissents and concurrences and partial dissents, nobody was able to command more than 2 votes for their reasoning. Well, what does that mean? Does it have any precedential value? In Ohio, there's something at the top of the case called the syllabus. And it typically says, 1, and then there's a sentence, and 2. Those are actually written by the court. In some states, they're written by the reporter of the decision, which is just a private company trying to do their best to say what they think it means. But in Ohio, that syllabus is the court syllabus, and the White Hat syllabus had 4 votes out of 7, meaning that all of the rest of that 60-some pages only means what the justices that were writing on that actually thought, and it doesn't have any precedential value. The syllabus is precedent. That's black letter law in Ohio, with 4 votes behind it. And the second line of the syllabus is that a charter operator has a fiduciary duty to the public school. Now, I want to tell you why that's so important. Up until now, the idea of the charter operator and the charter school was just a matter of contract. No different than buying janitorial services. We're going to hire Joe's janitor service to come in and clean the school once a week. The only thing Joe owes the school is to show up and clean the school once a week. And in return, the only thing the school owes Joe is to pay his bill every month. And the general understanding was that those contractual arrangements between a charter school and a charter operator were just that, contract. So whatever contract said is what the duties of the parties were. Now, the Supreme Court has decided in that syllabus, the second line of the syllabus, that a fiduciary duty applies. Now, what's a fiduciary duty? It's a lawyer word that means a position of trust, a relationship of trust. The way it works is one party is allowed to and entitled to rely on the utmost integrity and loyalty of the other party. So this is more like the duty that your lawyer or a realtor or a doctor would owe you, or a partner in if you went in partners to buy a hot dog stand. The two of you have a duty to each other. Now, what does that mean? That means if you've got a fiduciary, if a charter operator has a fiduciary duty to a school, that means it's not just what can I get, it's the opposite of caveat emptor, let the buyer beware. Now, we don't know anything more about what that means or what the court's thinking, because that's the only thing that got 4 votes to be a majority of the court. But I think that it opens up a whole new era in the relationship between the operators and the schools themselves. You're not allowed anymore, if you have a fiduciary duty, you don't get to drive the hardest bargain you can get and say, hey, watch out for yourself. You've got a duty at that point. If you're in a fiduciary relationship, you've got to look out for both of you, both sides, to be fair and open and loyal to each other. So,